Thank you all for coming, and if you'll please identify yourself, define your position, and make sure your light's on. Welcome.
There we go. I love it when a plan comes together. Thank you, Senator Bowling and Senator Kelsey, for the opportunity to speak to you today. I actually had to bring a real expert with me today, Mr. John Morris and Mr. Duran, who I have a great deal of respect for, as well as the court. Obviously, the commission gave this a lot of thought. But Mr. John Morris is here with me. He actually is an expert at Mr. Rabin's suggestion, and he's been encouraged to be bright, brief, and gone. Well, you know the hour is late, and we are very sensitive to your time. But if y'all would hear him out, I would be grateful on this issue.
You're recognized. Please identify yourself and tell us your position.
Thank you, Madam Chairman. My name is John Morris. I'm an attorney here in Nashville, licensed in Tennessee, also with the Middle District Federal Court, and am a computer.
Madam Chair, his mic is not on.
How's that? Now I can hear myself, and that sounds better. And have done a considerable. I'm sorry.
Would you please repeat your name and everything?
Sure.
And just start
John
all over.
Morris.
Thank you.
I apologize. John Morris. I am an attorney, licensed in Tennessee, also accepted to the Middle District Federal Court, and am a what I call e-forensics, the terminology trying to keep up with the reality of the number of devices and the sources of this type of data. I will tell you anecdotally that the primary reason that I think this is a challenging change to the rule is that when the word reasonable access is used, I'm not sure we're really defining that the way it needs to be looked at. The amount of time and the effort that it requires to truly analyze a computer to determine whether someone has truly violated the law and possesses this information is considerable. And I will give you a very real case that I worked on within the last 6 months, where a gentleman in a rural county was charged with possession of child pornography or exploitation of a minor, as the statute defines, and the best offer he had received was 10 years to serve. I received an image of the machine, actually, sadly, received the actual machine, handed it to me by the local police department, took that into possession under a chain of custody form, did a forensic image of the machine, and spent over 16 hours analyzing that machine and doing my research. This is not 16 hours in one sitting. It is, I will tell you, much the same as gumshoe detective work in the physical world. You find threads, you follow them, sometimes they're dead ends. And in this case, and I promise you I've heard this before, quote, it was only pop-ups. I wasn't really surfing this stuff. I found the unicorn in this case. I was rather surprised and shocked to find that it was just pop-ups. And I wrote my report with the evidence from my report, which the district attorney then sent back to the TBI, who reviewed my report, and I saw the response to the DA. It was 2 words: he's right. He was acquitted. The charges were dismissed, I should say. Right. But for those 16 and a half hours of analysis of that machine, an innocent man would have spent 10 years in jail for something that he did not do. Now, for me to go do that at a district attorney's office here in Nashville would be burdensome. In pick your county, rural Tennessee, I simply would not take the cases. I couldn't. I got into this accidentally. I was at the public defender's office on an internship during law school, and someone said, does anybody know how to read one of these computer forensic reports? And I made the mistake of raising my hand. I've spent over 30 years in technology in one way or another. I was at Microsoft for 17 of those. I have a deep background in this space. And what I found out was that the only company in town that used to do this for attorneys, Logic Force, stopped taking AOC rates to do this for indigent clients. And so until recently, to my knowledge, I was the only person who would do so. And so the economics, the time, and quite honestly, just the logistics. The machine that I use to do this analysis is a special machine. It is isolated from the network. It is never connected to the internet. That is a requirement. I receive these digital images, or the computers in this case, or phones, under court order, under seal. I have been shocked to get the actual computer handed to me, to get hard drives handed to me, not encrypted. And so I guess the thing that really kind of strikes me is that I can most assuredly tell you that when this data or this evidence is in my possession, it is more secure than where I have seen it elsewhere. I keep these devices in a locked cabinet. I'm actually procuring a safe. If the drive or the image that I receive is not encrypted, I encrypt it with the heaviest encryption available. And in the case of Dean Boland out of Ohio, who was prosecuted for possession of these images or this kind of material as a defense attorney, he got in trouble because he kept the stuff after he was done. Believe me, when I'm done with it, I delete it and I use a DOD level scrub on my machine because I don't want the FBI and their black helicopters showing up over my building. I'm very paranoid about this. So I think you really need to look at, we let the DA's offices have this for obvious reasons. They have to. It's evidence. The police departments have this for obvious reasons. It's evidence. But to mount an adequate defense for someone in these charges and to take the risk that they are not guilty, as this individual was in this case, because we are not able to do an adequate analysis of the system, which, again, I promise you, is time-consuming and requires intensive investigation in many cases, we are ultimately risking sending innocent people to jail and violating the constitutional rights people have to an adequate defense. There is no other way to analyze this data in many cases, and it is a quagmire of evidence and investigative work to sometimes get to the bottom of these.
Are there any questions? Yes, Leader Harris, you're recognized.
Thank you, Madam Chair, and I have a bunch of questions, but in the interest of time.
Pardon me, we're in session with the questions. Go ahead.
Okay, thank you, Madam Chair. I'm only going to ask one question in the interest of time. In the case you described or in your experience, seems like child porn would be one of the most serious offenses that one could imagine. How did the case get that far down the path? Because I would imagine the DA would have already done that work in the first place to make sure that the person arrested, that those weren't pop-ups. So how did this case even, how did that happen?
Let me briefly answer you in 2 points. First off, he ended up in the bullseye of the police over other things, and his computer was seized and analyzed, and then this came out. This wasn't the initial inquiry, right? Oftentimes, it is the initial inquiry. But the simple answer to your question is, and again, I know the guys over at the TBI and the local forensic people who do this, as law enforcement, when they find images, and quite honestly, for them, it's a simple process. They image the machine, they run an algorithm on the machine that does skin tone analysis that determines suspect images, and then those suspect images, which are a small portion of the literally millions of files on any given computer, are then either manually analyzed or compared against, without getting into technicalities, a list of, shall we say, known images. Once they find those images that are suspect or illegal, they're done. They don't do further inquiry to figure out how they got there. That person is in possession, and they are in violation of the law. Story over. As I was telling someone literally in the hallway who asked me that same question, that's where my work begins. And oftentimes I find out folks were just not behaving. Digital evidence doesn't lie. And the TBI and the investigators in these cases do not look further once they find them. That's where their inquiry stops.
Thank you, Madam Chair.
We're out of session. We're in recess right now. And I have a question. If it says in the rule that you would be reasonably available, and you're saying reasonably available at that point would mean you would either come back or have that for a certain amount of time. How does this rule preclude what you've just described that you did?
So reasonably available, and I think we can all agree that such terms get interpreted differently in different locations. Truly the only practical way I can do this analysis is to bring that into my lab, put it on this isolated secure machine, run the analysis, and oftentimes do the inquiries over multiple iterations, and when I'm done, then come back with my report. To have to go to a district attorney's office, my analysis workstation weighs over 75 pounds. All right, it has multiple driver arrays and all kinds of things that I won't get into. I can't lug that to a DA's office. smaller machines, that there are laptops that are used for forensics analysis, but they don't have the heft and they take much longer. So I'm simply telling you from a practical standpoint, to have to go to a district attorney's office with my equipment and do this and do it over multiple iterations, it's not practical. And therefore, I would argue, not reasonable. I would not at all be opposed to a vetting process to say that forensic analysts have to somehow be vetted. As an attorney, I had to be vetted, background check. There's a concealed carry permit holder in the state, you have to be background checked, FBI, fingerprints, global entry, the same. I'm not saying willy-nilly send this stuff out into the wild, quite the opposite. I'm saying that when I have it, I promise you it's more secure than where I've seen it in government possession. And so my recommendation would be an amendment or a change to the language to specify under what conditions forensic analysts have the ability to take this into their lab and do the analysis. But my deep fear, because we've already seen this in the current implementation, in some jurisdictions you can get access to this data, in some you can't. And with all due respect to the comments made earlier, I'm not asking for copies of pictures. I'm asking for a forensically sound image of the person's system, because I'm not looking at the images. I'm looking at how they got there, where they came from, what behavior led up. And in another case that I don't have time to go into, the concern was it was a divorce situation, and the soon-to-be ex-wife had provided this thumb drive full of images saying it was from him, and my job was to determine whether he had downloaded them or she had planted them.
So you're saying today, in the age of uber technology, we need to have an ability to go into the very computer itself forensically to determine the fingerprints and the footprints that are there.
Couldn't have said it better, and I will add on to that comment and simply say that with the constant change in technology, one might say, well, a system that can do that today, tomorrow may not. It is to do what I do is a constant effort of keeping up. A new version of an OS on an operating system on a device comes out, and I literally have to relearn the forensic analysis because things move. And there's different on your cell phone alone, just to scare you, there are over 30 different locations on an Android phone that may be tracking your location at any given time that you don't even know about, right? And going and finding those, and then realizing that when the new version of the iPhone comes out, it's all different, potentially. It's a constantly evolving world, and that's not something you put in a box and carry into a DA's office.
With having said that, you said that the company that did this stopped doing this because of the cost or whatever. They stopped taking the rates. How many people, such as you are, Mr. Morris, are actually doing this?
To my knowledge, there is one other company in Tennessee that does cell phone analysis, and that is Blackwatch out of Memphis. And that was started by the wife of an attorney who saw the same problem I did. They do not do computer analysis. They do not do cloud analysis. And as I'm sure we're all aware, the cloud and things on the internet and in social media, I testified this morning in a case about Facebook postings that were allegedly posted by the defendant that it was my opinion they were fabrications. The cloud is a whole different ballgame, and to my knowledge, there is no one in the state that can handle that. In fact, anecdotally, the husband of the lady who owns the other company hired me on a cloud forensics engagement.
That sounds like a personal issue.
Fortunately, we are all good friends. But
Thank you.
it's a skill set issue in that case.
Certainly. Thank you very much. Were there any other questions, comments? Chairman Kelsey?
Thank you, Madam Chairman. I guess one follow-up question then to Mr. Duran, because there was one allegation made that perhaps this is a violation of the defendant's constitutional rights. Did the commission look into how other states have handled this issue, and if so, do you have any input on how they're doing that?
We did, and we looked at a number of cases under the federal law, which basically is the same. And it was the commission's belief that the addition of subsection C provides the trial court the ability to control the circumstances under which defendant's counsel or expert might be allowed access to the materials or the device upon which the material is found.
So Section C is actually a remedy should Section B fail. It would give them the opportunity to appeal.
Should they be able to establish that for any reason, the materials are not reasonably available?
May I comment?
Yes, you may.
My argument would be
Please
that
identify yourself again. Thank you.
I am sorry, John Morris, forensics expert in this context. I would simply suggest and argue that that is too much variance in the application of the right to present a defense. And by the way, just to be fair, I don't agree with the implementation at the federal level in the Adam Walsh Act as it pertains here either. I think there are issues there that are yet to be potentially litigated across our country. Again, the Dean Boland case being a prime example out of Ohio. My suggestion or my request or whatever the appropriate term is that that exception or that definition of how this material might be released to an expert for analysis should be codified in the rule, not left to the discretion of any number of different opinions, because let's be honest, this is not a popular topic.
Thank you. Do we have any other questions, comments, observations? Are we ready for the vote? We're back in session with no further comments or questions.
There's one further section.
We're out of session.
I'm sorry.
I want to
This one.
thank you for the opportunity to speak before the committee today.
Thank you.